Okay, we're going to go ahead and get started. So, welcome again uh, to the Pre and Postnuptial Agreements hosted by the Atlanta Divorce Law Group. I'm Shawna Woods. I am the managing partner here at the Atlanta Divorce Law Group. And one of my specialties is pre and postnuptial agreements. I've taught classes on them at various colleges throughout Georgia, and I am the one who generally oversees the prenuptial and postnuptial agreements here. We are the Atlanta Divorce Law Group. We now have been this firm has been formed now for 9 years. But what you're looking at here in this picture is over 80 years of combined experience at the Atlanta Divorce Law Group. Next slide. Okay, the slide's not moving. Hold on just a second, guys. Okay, a prenuptial agreement can also be known as an anuptial agreement. These are interchangeable words and then they mean the same thing. Basically, what you're looking at is forming a contract prior to marriage that's going to outline what you keep as separate property and what you denote as joint property. And it's going to do it regardless of what the law of Georgia says or what the law of any state in which you are seeking a divorce says. Once you have a valid prenuptial agreement, this can be enforceable across any state. What the purpose for was originally, because these predate when divorces were easily obtained. And the purpose originally was to keep property that you had inherited separate from the marital estate so that you could pass it down to who you wanted to or pass it to someone else even outside the family. So originally, prenuptial agreements were really a way to control the wealth that was coming in a marital estate. Nowadays, it's more about protecting your finances in the event of a divorce. So OCGA, which is the governance of the statute, because in Georgia, it has to be done by the statutes. It is basically your contract that you're creating prior to marriage that's going to determine what your property rights are and determine if you have any spousal support or if you want to leave that to the courts or if you want to say you don't want spousal support. Any contract has to have consideration. And the consideration in a prenuptial agreement is the marriage. So, in order for this prenuptial agreement to be put into effect, there also has to be, of course, a valid marriage. Postnuptial agreements, I am going to go back and forth between the two because the biggest difference between a prenuptial agreement and a postnuptial agreement is that marriage. You can enter into an agreement post marriage that again divides up what your property is going to be, addresses spousal support, and determines how much of the assets and debts are going to be allotted to each person. It is the same requirements as far as the statute and what you need to do post-divorce or pre-divorce. So I am going to use some of these interchangeably together in case you are looking for a post-nuptial agreement as well. The post-nuptial agreement generally it comes about in about three different ways. Sometimes you don't have time before the marriage to get this prenuptial agreement signed. You waited a little bit too long. You weren't able to do it before all of that hubbub and the wonder of the marriage came through. We recommend in those cases you go ahead and make that a postnuptial agreement because you cannot sign a prenuptial agreement right before the wedding. Again, I want to emphasize this. What do I mean right before the wedding? I would give it at least 10 days prior to the wedding, and that is really close. My personal suggestion is that at least 2 months prior to your wedding date, you're already signing the prenuptial agreement. So this should be part of your checklist coming into your marriage, coming into the wedding. But right after the wedding, that solidifies this was your intent. You simply got away with the time, got away from you. Other times can be, and it happens. I don't know why a spender always wants to marry a saver, but that happens a lot. And instead of seeking a divorce or separating, right, and letting this be the cause of the friction in the marriage, they go ahead and they divide up what they want their assets to be because they want to save the marriage and focus on the love without having to worry about the finances. That's a great reason for a postnuptial agreement. And then the third kind really is you're kind of looking at we may have to go down the road of divorce, but we're trying to save the marriage. It may come after an infidelity, whether that's a physical infidelity or a financial infidelity. It may have come after some rough period of time. And this is the contract that you guys are thinking about. All right, we are still in love. We are still trying to work through our marriage. And while we're doing that, we want to go ahead and put this on paper what our intention is if this does not work out. As I said earlier, a prenuptial agreement is very statute specific. It must follow certain rules in order to be enforceable. But once those rules are followed, courts favor enforcing pre and postnuptial agreements because courts are in favor of enforcing contracts that adults have made between themselves and decided for themselves. What must it say? It has to be in writing. There has to be a valid marriage. Of course, both parties have to sign it. And it needs to have two witnesses in addition to a notary. And that is a very specific requirement that not all attorneys and firms are following, but need to be following. The next one is very important because one of the rules of a pre or postnuptial agreement is that you must have a full and fair disclosure of all of your assets and debts. Usually we do this by having each party sign an affidavit listing out their assets and debts and attaching it to the prenuptial or postnuptial agreement. Can it be done without the affidavits? It can, but not at our firm. We don't feel that it's a full and fair disclosure unless you have signed that you attest to it, and that way we can prove you knew or they knew about you. All right. If I Right, they just said my internet is unstable, which I always love hearing something's unstable. They just said it was unstable, so if you can't hear me, like do a wave or something and I'll repeat something I just said. Going back to these financial disclosures, if you accidentally leave a little something off, say perhaps 20 years ago, 10 years ago, you worked at a job for a few months and you have a small 401k that you forgot existed, it is not going to invalidate your prenuptial agreement. But if you forgot you had $100,000 in a 401k, it probably will. So you need to make sure that you're having honest conversations about what your true assets and debts are. On here, we have that cooling off period, and this it goes towards that prenuptial agreement that we were talking about. What that means is the court does not want to see fraud or duress in the signing of a prenuptial agreement. And as you can imagine, if one was presented with a prenuptial agreement a day before or even the day of a wedding, there would be duress to sign this with all these people showing up to witness your wedding. The court frowns on this and, in fact, says there must be a reasonable amount of time between the signing of the prenuptial agreement and the actual wedding. Reasonable is up to a court to decide, but we know that case law says at least 10 days is reasonable. So we use that mark in order to ensure that our prenuptial agreements are enforced in court. What can we put in a prenuptial agreement? When we talk about a prenuptial agreement, these are focused on your assets and your debts, or what your assets are going to be and what your debts are going to be. So first, let's talk about if you need to determine What would happen if you got a divorce here in Georgia? Does Georgia law say versus what do you want your prenuptial agreement to say? In Georgia, anything acquired during the marriage, whether it's an asset, whether it's a debt, whether it's in your name or your spouse's name, is considered marital, very few exceptions. Now we can go over those, but it is mostly considered marital and subject to division. Now, Georgia doesn't say you're going to divide 50-50. Georgia says we are an equitable division state, which means you get to argue about what's fair, which is one of the reasons a lot of people want to have a prenuptial agreement, even if they decide that their marital property is going to be divided 50-50. They don't want to have a long divorce case battle arguing when they're now mad at each other what's fair about the money. They want to make that determination as they're coming into it with respect and love for each other. A separate asset, if you're according to Georgia law, is anything you had prior to the marriage that you didn't add to during the marriage, right? So if you have a house that's completely paid for and it increases simply because of market value, and you kept that in your name and that was yours before the marriage, that's still separate property. But if you have a house that wasn't paid for and you pay on it during the marriage, that is now both a separate piece of property, has some separate components, and a marital piece of property because the salary that you earn is considered a marital asset and marital money according to Georgia law. So if you have separate property that you want to keep separate, but it's not paid off or you may put money into it, a prenuptial agreement is a really good idea for you. Retirement also is considered joint asset. Remember, I said anything that's acquired during the marriage, doesn't matter whose name it is. A lot of people want to keep their retirement separate in the event of divorce. Debts are another reason to to have a prenuptial agreement or a postnuptial agreement. Your spouse's spending habits are your responsibility in accordance with Georgia law. Citibank isn't going to come after you if your name isn't on that card. But if you go for a divorce, you're subject to paying probably half of that debt unless you have a really good argument why you shouldn't. And the longer you're complicit in allowing them to build up that debt, then the longer the court's going to look at you and say, you knew about it, you have to share in it. So we need to be very careful when we're coming into either a postnuptial agreement where we want to keep this separate or a prenuptial agreement that you include your debts and who's going to pay for them and how those are going to be paid in your prenuptial agreement. Alimony, also called spousal support. These two are again interchangeable words. What that is that after marriage, one spouse pays the other spouse a certain amount of money for a certain amount of time. Usually here in Georgia, it's what we call rehabilitative spousal support, which helps somebody who may have been staying home get back on their feet. Georgia doesn't have a very strict law in alimony. It doesn't say you're married for a year, one person gets this. It doesn't say if you're married 5 years. It gives no timeline. It gives no structure for determining how much. So it's a little bit of the Wild West over here when we start doing spousal support in divorce cases. If at all possible, I strongly recommend that you address the spousal support slash alimony support directly in your prenuptial agreement, thinking through, is this something that either one of us may have a need for in the event of the demise of the marriage? One of the questions I always ask is one of the parties going to stay home with the children? And if so, should that be accounted for in the event of a divorce, that they gave up a part of their career? Business interests. If you build a business without a prenuptial or postnuptial agreement, and your spouse does nothing for that business, like they didn't help, they had their own job, their W-2, they're building their own thing, and you build a business, they can be entitled to seek half of the value of that business. And I want to emphasize that again, the value of the business is determined by an appraisal of sorts. And oftentimes with small businesses, you're not able to write a check for half of what the value of the business is determined to be. So my recommendation, especially for our small business owners, is to make sure in your prenuptial agreements or your postnuptial agreements, you're keeping your business separate. If you have partners, this may be in your operating agreement that you have to keep your business interests separate from your marital property. Inheritance. In Georgia, inheritance is separate property. It can be turned into marital property, however, if you put it into an account in both the parties' names, or if you put it into a property with both the parties' names on it. You want to make sure you're addressing that in your post or prenuptial agreement, because a lot of times what happens with our inheritance, we want to pay off the home. But in the case of a divorce, we want to make sure that it's accounted for on our side of the marital balance sheet. How is this different from a marriage where we keep all our own accounts in our own names? Well, I think I've gone through that a little bit. That doesn't protect you. Just because you have decided within yourselves that that is what you're going to do, unless you trust your spouse 110%, then you need to write it down and put it into the correct format in order for Georgia courts to enforce it. Because they're not going to listen to he said, she said from what we discussed. They're going to address Georgia law unless you have a pre or postnuptial agreement. I assure you the technical difficulty is me, not my laptop. Um, the court always has the opportunity to accept or deny a prenuptial or postnuptial agreement. I've never had a court deny one of our pre or postnuptial agreements because we follow the rules. And there's a statute in particular that says it is Georgia court's intention to enforce contracts if at all possible. So your courts are going to be looking to enforce it, but if there is one thing that they haven't followed in the statute, it will be set aside. Um, the court down here, this gives you the bright line kind of examination. Is the agreement, was it obtained through fraud, duress, mistake, misrepresentation? Is it unconscionable? What does unconscionable mean? Let's talk about that for just a brief moment. For instance, if you have somebody who is older and marries somebody who is younger, and the older person has acquired quite a bit of wealth. And you sign a prenuptial agreement that says this younger person is going to get nothing because they've already acquired it all. And they're only going to have what is they can just earn in just their name. That probably is going to be found unconscionable because this person's probably going to give up a lot to be with this person. So you're going to have to listen to your attorney about something like that, where you're trying to cut the person completely out and they didn't have the opportunity of earning that you did. Again, right after the wedding, I think we went through these. And this is one of my favorite ones to talk about because what you cannot put in a prenuptial agreement or a postnuptial agreement is anything to do with your children or future children. It is always within the court's purview to decide what is in the best interest of the children at the time of the separation or at the time of the divorce, and that includes your parenting time and that includes your child support. The courts always have the right to determine that. And thinking it through, you want them to always have the right to determine that.